Good morning, Mr. Killen.
Good morning, my lady. My lords, I appear with my learned friend, Mr. Partridge, on behalf of the appellant, Tyson International Company Limited, and my learned friend, Mr. Brocklebank, King's Counsel, along with Mr. Grant, appear on behalf of the respondent, partner Reinsurance Europe SE. This appeal is brought from the order of Mr. Stephen Housemann, King's Counsel, sitting as a Deputy Judge in the Commercial Court and dated the 15th of December 2023. Before Mr. Housemann were two applications, one for a stay of proceedings pursuant to Section 9 of the Arbitration Act, and another for anti-arbitration relief pursuant to Section 37 of the Senior Courts Act 1981. The judge granted the Section 9 stay and refused on a contingent basis the anti-arbitration relief. This appeal is brought with the permission of the judge against both of those grounds. In a nutshell, we say the judge was wrong on both conclusions. On ground one, we say that the judge did not properly construe the documents so as to conclude that the facultative certificate did not amend or supersede the market reform contract. The reason why the judge appears to have gone wrong appears to be that he started from the assumption that this was a two-contract case, rather than analysing whether that was correct. So at paragraph 2 of the judge's judgment, he stated that the unusual feature of the case is that there are two distinct contracts, and considered that the outcome was determined by which contract prevails. But we say that his jumping in point was just simply too far down the line. He assumed the answer to the question of whether the facultative certificate was a contract of reinsurance. The judge should have asked whether reading the text of the MRC, which was agreed by all to be a contract, alongside the text of the facultative certificate, whether that latter document was intended to change or supersede the former. We say that had the judge carried out the analysis through this lens, he would have reached a different, and we say the right conclusion, as a matter of interpretation of the two documents. On ground 2, we say that the judge approached the issue of delay in the wrong way. The judge's approach was, we say, infected by the fact that he had found against the existence of an exclusive jurisdiction clause. He found that there was delay without considering the particular features of the case, and we say that these amounted to relevant considerations that were left out of account and an improper approach to the legal test to be applied. So, my lady, my lords, with those words of introduction, I suppose I better turn to housekeeping just to check that everything is before the court. There are 3 bundles, which I think stretch across 4 volumes, a core bundle, a supplementary bundle, and 2 volumes of authorities. There are also 3 skeletons before the court, the appellant's skeleton, respondent's skeleton, and a supplementary skeleton from me, which was tucked at the back of the core bundle in order to not throw out imagination.
Seems rather amazing to me that there are 2 fat bundles of authority. It will be interesting to see how many we need to refer to.
Indeed, my lord. I will perhaps answer that question at the end to see how many I have had to refer to. I anticipate, and I should say, there is a fair bit to get through. I think I will have to go at a fair old lick, but I think it can be done.
It will be done.
Of course, of course. My lady, I suppose that some of the authorities may be referred to in a tangential way, but if we need to get stuck into them, then we can. By way of overview, to set out my submissions, they'll be in 6 parts. Part 1, I intend to address the relevant background. I have endeavoured as best as possible, I hope, to make that background the uncontentious background. Part 2 is to address this preliminary question of the fact-law distinction that my supplementary skeleton addresses, whether the issue under ground 1 is a question of fact or whether it's a question of law, or, I say, reviewable as though it were a question of law. Part 3 is to set out my client's case on ground 1, and my lady, my lords will have noticed from the skeleton argument there are 3 strands to this argument. The first is what one might call pure interpretation, so construing the 2 documents together. The second is also, we say, a point of pure interpretation but is separate, which is the question of the contract change provisions. And then the third is commercial common sense, I'm sure the court will be grateful to hear that last point should be taken very quickly. Part 4, then, is to respond to any sweep-up points on the respondent's case on ground 1. The majority of them, I think, will be answered in the course of my submissions as part of Part 3, but there are nevertheless some hangover points. Part 5 is then to turn to ground 2 and set out briefly the background and the judge's findings on delay, before finally Part 6 to make my client's submissions on why we say the judge's contingent finding was wrong.
And Mr. Killen, you can assume that we've all read very widely.
I'm very grateful, my lady. In that case, we will certainly finish in time. I should say, on time, my learned friend and I have had a discussion. We propose uncontroversially split the time equally. I hope that I will finish at about 1:45, just before lunch. My learned friend will pick up from there, and that leaves me 15 minutes for some very brief reply submissions, if necessary, at the end. So, turning then to Part 1, and to put the grounds in context, as I say, by way of very brief background, my client is the captive insurer of Tyson Foods, and these proceedings arise out of a catastrophic fire at a poultry rendering facility in Huntsville, Alabama, on the 30th of July 2021. My client has agreed to indemnify in respect of the fire and now seeks to call upon its facultative reinsurance agreements. The policy agreed between my client and its insured, Tyson Foods, I refer to as the captive policy. It's also referred to, I think, in 1 or 2 instances as the direct policy, but they are the same thing. That is in the core bundle at tab 9, and we'll be going to it shortly. My client sought reinsurance of its liability under the captive policy, and a primary layer of $75 million was arranged with Beazley and 11 other underwriters. That policy is referred to as the original policy form, and that was agreed by way of an MRC, and it includes the complete terms of the captive policy as part of that original policy form. That MRC was before the judge. It's not in the appeal bundles, but it's not, as I understand it, in dispute. There is one section of it in the appeal bundles, which we will look at, which is an endorsement at the end of it. Partner Re agreed to reinsure 10% of the $225 million excess of the $75 million layer insured by Beazley and others in the original policy form. And so it's the second layer up that we are concerned with today. Now, an agreement for reinsurance to this effect was concluded between my client, Tyson, and Partner Re by conclusion of a policy of reinsurance in the form of the market reform contract. That contract was signed and stamped by Partner Re on the 30th of June, and the cover provided was for the period from the 1st of July 2021 to the 1st of July 2022. That contract provided for English governing law and an exclusive English jurisdiction clause. Now, at this juncture, upon receipt of the signed MRC, my client's broker, Lockton, sent an email in acknowledgement in which it stated, "Many thanks for the signed slip and for all your hard work on this renewal. Fact certs will come through at some stage." And it's not in dispute that fact certs in that email, and that email is in the supplementary bundle at page 163, but we don't need to go to it now, is a reference to the document referred to by me as the facultative certificate, and by my learned friend, I think, sometimes as the MURA, which stands for the Market Uniform Reinsurance Agreement. I think my learned friend sometimes also refers to it as the Reinsurance Agreement, but it is the same document. Now,
is this the one in agreement of facultative reinsurance, bracket the agreement, is that the document?
It is, yes, my lord. Now, all parties are agreed that if the clock stopped there, prior to that second document being sent, there would have been an agreement concluded between the parties for Partner Re to reinsure Tyson on the terms of the MRC, including English governing law and jurisdiction. However, on the 7th of July 2021, Tickle's broker sent to Partner Re the document to which I've just referred to, which I refer to as the facultative certificate. It includes, as the court knows, a New York seated arbitration clause and of sorts a New York governing law clause. On the 8th of July, it was signed and stamped by Partner Re, and it was returned to Tyson. It was said by the judge, I think, to have been signed by both parties. That's at 32 of the judgment. That's not correct, as one can see from the document. But I'm not saying that too much turns on that.
If it was a, I mean, maybe you'll come to this, but one of the things some of us have been wondering about is if it was a certificate, what was it certifying and to whom?
Certainly. Well, we say it was a certificate in the sense that it is a document for information. It is a summary of the cover, and it is certifying to the parties that that policy has been issued. The evidence from my client was that that type of document was expected in the market. So in that sense, it is simply a document which a party can refer to say, well, this is the layer, these are the parties, and that's the outline of the reinsurance. But it is simply a summary of that cover. It's not where one would look to find the cover itself.
Well, it seems very odd to have a summary of the cover which is in completely different terms to the contract that's being concluded, if that's all it is.
Well, it does, yes, certainly, and we say that is an error. That is what has caused these proceedings, is the ambiguity between the two. The fault was using a form for the certificate that was inappropriate. But that doesn't mean that what is clearly, we say, a certificate gets promoted to anything other than a certificate.
Sorry, in the previous year, and we'll come to that, there was also a certificate. You've just said of the certificate that we're concerned about, and I call it certificate, I know it's also called Mura, was in an inappropriate form. But it was in the same form the previous year, wasn't it?
It was.
But then was subject to the point that it was expressly said to be subject to the MRC.
Yes.
But to say, therefore, that the certificate was in an inappropriate form is a bit difficult, isn't it? Because that was the form you used the year before, and presumably is the form of a certificate. Call it that.
Yes. I suppose perhaps I should have said unfortunate rather than inappropriate, but the point is the same. I suppose, and I recognise this is probably just speculation, but the inappropriateness didn't come up as far as I'm aware the year before. There was no dispute over this. As far as I'm aware, there was no clash between New York arbitration and a dispute and the English jurisdiction clause. Nobody referred to that certificate, as far as I'm aware, in support of any claim or the like. So it was unfortunate. It was there the year before, but the fact it was in the same form the year before, we say, is really neither here nor there. The unfortunateness was not discovered until these proceedings, or was not revealed until these proceedings.
Well, the year before there was, you say, a hierarchy term.
There was.
Which, if you're right on the interpretation of that, and I think the other side disputed, but if you're right, that solves the problem. But you didn't have that in the following year.
Yes, but I suppose it doesn't make the form any more appropriate if the form is the same.
But
I had two questions really. One, why did you need to send anything at all on the 7th of July? What was the purpose? Nothing more needed to be done if the first contract is a contract. And secondly, although you refer to the calling it a contract, it's headed agreement and you go through it. The next bit is terms and conditions. And it sets out, I forget how many, 30 or 32 things that look like terms. So why do anything at all? And why do you call it a certificate when it says it's an agreement?
Certainly. I suppose, my Lord, the answer to the first question is that which I gave to Lord Justice Males, which is that it is a document that's expected, was my client's evidence, in the market. One expected to have a certificate at the end. One can refer to the certificate in order to say, well, the insurance has been placed without having to go to the long-form policy to see the insurance. The second one, and that I hope I will address more fully when it comes to comparing the two documents. Now, we accept that the certificate, if it were the only thing that were issued, could act as a reinsurance contract. But our point is that as a matter of interpretation, when one does what is necessary, which is compare the two documents and put them in their factual background, that one sees that in fact the certificate is wildly deficient compared to the MRC. And so when one views it in that sense and carries out that objective interpretation, analysis of the documents, one can see that the certificate is simply a certificate. It is not intended to be a full policy of insurance that replaces. It is not intended to be a primary contractual document. But I hope that I will make that point good when I come on to the comparison of the two documents. So, my lady has already referred to the last bit of what we say is the relevant background, which is the fact that there was a prior year of insurance, and I will go to those later. I propose then to turn to the fact and law distinction point before going through the two documents.
Just one other aspect of background. Did I see that when what you call the certificate is sent to partner Re, they are asked to agree it?
Yes, that is correct. It says for agreement, I think, says the email.
So what are they being asked to agree?
We say the form of certificate. And that doesn't necessarily tell you. Certainly it's a factor to be weighed into the balance, and I hope to establish that when one has all of the points weighed together, it certainly doesn't tip the scales and doesn't get close. It could be said that it was being agreed because it was a contract, and indeed that's what my learned friend says, that's what the judge said. We say that they are simply agreeing the form of certificate because the certificate is an administrative document. It is both parties' case that the premium moved once the certificate was issued in an agreed form. But that doesn't make it a contractual document, and that doesn't make it a primary contractual document, such as to supersede what is very clearly a full policy of reinsurance that had preceded.
Sorry, before you go on, you say they were being asked to agree the certificate, but isn't it your position actually that certificates were always the same?
Well, they're not quite the same because, of course, the policy number, the party, the layer, the information that is the summary of the cover is
obviously
in that sense related to the underlying contract. But yes, everything else, the terms, are
standard.
Exactly.
And you only need page 1, would you, of this document? You only need page 181 as a certification to tell you what had been certified. Or is that correct?
I think page 1 and a bit of page 2.
Right, okay. The premium.
So I think it's got the premium and the territory on page 2. But primarily it is page 1, and then some other information on page 2, and the reference to the master programme number. And then we say that what then follows, the terms and conditions, the standard printed form that's bolted onto the back, that is the unfortunate aspect, certainly from my point of view. The first 2 pages, I think if they were there, we certainly wouldn't be having this argument. It is the fact that there is a block of standard printed terms at the back of the certificate which causes the issue and which requires, we say, this court, and what the judge should have done was to compare the two, see what they're both doing, put them in context, and decide, is this what it appears to be from its first 2 pages, a certificate with some standard terms appended, or is it really intended to be the reinsurance agreement?
Was it both a certificate and an agreement? They put together.
Well, I will perhaps leave my learned friend to see if he decides to take up that point and then reply to it. But I think that part of my learned friend's case is that they are to be read together. Not, I don't think, because he says it's a certificate and an agreement, but because he says it is itself a new policy. My Lord, I think the analysis would be the same, though, which is that if it were a certificate with an agreement stapled together, then the question for the court is still, putting them in context, did the parties really intend these standard form terms to supersede? And we say the answer is the same. So, my lady, my lords, turning to the part 2, fact-law distinction. I've filed a responsive skeleton on this. I hope I can take it relatively briefly. But my client's case is essentially in 3 parts. First, we say that questions of construction or interpretation of the meaning of documents are not strictly questions of law in the sense that that phrase might be used in ordinary parlance, but the courts have taken the pragmatic view that they treat questions of objective interpretation as though they were issues of law. And that is part 1. So we say that asking whether this is fact or law in the sense that those words are ordinarily used is we say, apt to mislead. What one needs to look at is whether this is a question of interpretation. And the second point we make is that we say that all of the questions that are before the court, all of the 4 arguments that are before the court, certainly the first 3, and I give my learned friend the benefit of the doubt on his rescission argument, are, we say, questions of objective interpretation of the documents. So they either are, or they are akin to, questions of contractual instruction, and so they are treated as though they were questions of law.
As I understand it, there was no oral evidence before the judge, and nobody suggested that there should be. Is that right?
That's correct, my lord.
And he made findings that there were no customs or practices or market understandings either here or in the States.
He did. Yes, my lord.
And incidentally, say there'd never been the first 30th of June document, and there'd only ever been the second one. Would there have been a certificate needed for the second one if that had been the only one? Would the party still want a certificate setting out the premiums and the territory and the coverage?
My lord, all I can say is that wasn't what happened.
No, I appreciate that, but the question then is a different one. If you have this kind of insurance policy, is the expectation always that whichever contract is the contract, it will come with a document called a certificate, which will give certain information to do with the parties, the insured matters, and the premium and the territory?
I suppose, putting it neutrally, my lord, my case is that there will always be a policy of reinsurance.
Yeah.
And our evidence was that in this programme, in these circumstances, it was always followed by a certificate. I'm not sure I want to go into whether if the second document had been issued first, there would have been a subsequent document, because that just simply isn't the case.
This is what happened.
My lady, my lords, I think I had made my first 2 points, which is treated as questions of law, and these are or are akin to questions of contractual interpretation. I have a third fallback point, which is that alternatively, to the extent that this is not a question of construction, which is or is so sufficiently closely akin to contractual construction, then picking up the point my Lord Justice Mayles made, this wasn't a case where there was oral evidence. There wasn't a trial of fact. The judge's findings and the findings that this court is being asked to make do not depend on any such issues. And so this court is perfectly able and should, we say, decide the issue. My first proposition is made good by Lord Hoffman's speech in Carmichael and National Power. It is extracted in fairly full order in my skeleton, but it might help if we turn it up quickly. It's in the Authorities Bundle, tab 2, and it starts at page 52 of the report. Perhaps whilst my lady and my lords are finding that, I briefly set out that Carmichael was a case which concerned a question of whether tour guides for power stations were employees or were workers, and that depended on whether there was a mutuality of obligation between them, and so one needed to look at whether there was a contract and whether that was a contract of employment. That background obviously is not particularly relevant to the present case, but what is relevant is Lord Hoffman's speech where at D on the report, page 52 of the bundle, he adds what he says are a few words only on the troublesome distinction between questions of fact and questions of law. And he quotes there from Lord Devlin in the Hamlin lectures, Trial by Jury, and makes this point that I've made as part of my first point, that there are two types of questions of law. First, there are questions which cannot be correctly answered, except by someone who is skilled in the law. Secondly, there are questions of fact which lawyers have decided that judges can better answer than juries. That judges can answer better than juries. And then notes that in the second category is the construction of documents in their natural and ordinary meaning. Now we say that is precisely what this case is about. We say that the arguments that are before the court are essentially four. One from my side and three from my learned friends. My argument is the facultative certificate did not amend or supersede the MRC. My learned friends' three arguments are that the facultative certificate did amend or supersede so far as an inconsistent. That is the precise mirror, we say, of my argument. Third, that the facultative certificate and the MRC are to be read together. And fourth, that the facultative certificate impliedly rescinds the MRC. Now those all depend in turn purely on a review of the documents against their objective background fact. So we say that they are all reviewable questions treated as though they were questions of law. We also have to point that there are similar arguments in other cases which have been dealt with at an appellant level, and I've referred in my skeleton to RTS and Mulcahy. That's at tab 5 of the authority bundle. It should be in the same volume. My lady and my lords are still in the same volume. This was a case which concerned the supply of automated packaging machines to, I think, a dairy. And the question was whether there had been a contract agreed, and if so, on what terms. That point is made good at paragraph 4, which is at page 83 of the bundle, where there, and I think it's Lord Clark is giving the judgment of the court, says the essential issues in this appeal, which is brought by permission given by the House of Lords, or whether the parties made a contract after the expiry of the LOI, it's the letter of intent contract, and if so, on what terms. As to terms, the argument centres on whether the contract was subject to some or all of the MF1 terms as amended by agreement. Now, the issues as they were set out there are, we say, strikingly similar to the issues in this case. And one can see from paragraphs 35 and 45 of the judgment that the court went on to consider these as questions of interpretation. Paragraph 45 is perhaps most relevant. That's at page 97, where it said the general principles are not in doubt. Whether there is a binding contract between the parties, and if so, upon what terms, depends upon what they have agreed. It depends not upon their subjective state of mind, but upon a consideration of what was communicated between them by words or conduct, and whether that leads objectively to a conclusion that they intended to create legal relations and had agreed upon all the terms which they regarded, or the law requires as essential for the formation of legally binding relations. And we say that is, in essence, the question and the approach here. And it's clearly something we say that this court can do.
Although it's something that this court can do, paragraph 45 does make clear that the question is not so much interpretation or construction of the contract, but what is, from an objective point of view, the intention of the parties. Now, it may not make very much difference, but it's a question of whether the parties intended something to be a contract, rather than a question of construing a document. You may get to the answer through seeing what the document says, but ultimately that's what you're looking for, isn't it? And the same is true here. The question is whether the parties viewing their conduct and statements objectively, including the documents which they exchanged, intended the MURA to be a contract.
Well, I suppose, my lord, that was why, I suppose in recognition of that, we say, paper-thin distinction between the two, we say it's either akin, it is, or it is akin to a question of contractual construction. The question of whether it applies at all, I can see, is akin to. Other parts of the arguments which are before this court are, we say, very squarely, purely contractual construction. So the meaning of the contract change provisions, that is, we say, a pure point of contractual construction. Whether the two documents can be read together, as my learned friend urges, is a pure point of contractual construction. And those points, to some extent, either do or do not arise, depending on the outcome of the first point. So
well, you would only consider whether the two contracts can be read together if you have concluded that they were intended to be contracts.
Yes, but of course, my lord, if you haven't concluded that the second contract was intended to be a contract, then I'm home and dry. So I suppose the question is, would it be realistic for this court to refuse to engage with the first question, recognising that questions 2 and 3 are questions to which there is, as a matter of contractual construction, only one right answer, and therefore the judge was either right or the judge was wrong?
Well, I wasn't really challenging you about whether we should engage with it. I'm simply seeking to clarify what, when we engage, we are trying to find out.
Of course. Well, my lord, my answer to that is that what we're trying to find out is whether the judge was right or was wrong. And whether the judge was right or wrong, we say, is binary, because this question is like a question of, if I can call it contractual construction, strictly sensu. If it is a pure question of unarguable contractual construction, then there is only one right answer. This distinction, we say, is so small as to not make a difference, and the approach, we say, is the same. My lord, I don't think I need to repeat the third point, but I noticed that my Lord Justice Mail had a similar question in Smith Salvage that was quite similar. I think your comment was obitous, so I didn't trouble the court with another authority in the bundles. But that simply, we say, is the approach that this court is well placed to review a question where the question does not involve underlying oral evidence or other fact-finding. So, for those reasons, we say that the question to be determined under ground 1 is, we say, a classic case of construing the documents. Whether it is a question of contractual construction or akin to a question of contractual construction, we say doesn't affect the approach. This court can consider and should consider whether the judge was right or was wrong, and that is binary. It's certainly not, as my learned friend has suggested, a case where this court can only interfere if the judge has gone wrong in a way that no reasonable judge could have. We say that puts it too high, and that fails to recognise the arguments that are before the court. So, with that point out of the way, I turn to part 3, which is the process of construction. Now, as I set out, this part of our argument has, we say, 3 strands. First, the interpretation of the 2 documents against their background. Second, as a related but an adjunct point, the contract change point. And third, commercial business common sense. Now, on interpretation, we have essentially 4 points of construction of the documents, supported, we say, by 3 buttressing background points. The first point, we say, is that facultative certificate does not say, on its face, that it is intended to amend or change the MRC. Essentially, my learned friend's case is that such a condition is to be read in And we say that cannot happily be done.
But it does say it's an agreement, and it sets out all the terms and conditions. And if there'd never been the first document, I don't think anyone would say it wasn't a contract. So it may be difficulty in saying that legal document changes previous earlier legal document and varies it so that previous legal document continues to have existence but in a changed form. But if it is a separate, on its terms, legal document, and if it appears to be inconsistent with the first one, might we not say, well, that's the one that they now intend to govern their relations? We wouldn't have to say we're varying, because it's not varying, it's simply saying this is how we govern our relations going forward.
Well, I think, my lord, that is my learned friend's secondary or tertiary case, which is essentially a suggestion that there's implied rescission. That is something I'm going to come on to. We do say, though, I suppose, to just lay down in outline what our point is on implied rescission. We say that in order for a later agreement to rescind an earlier agreement, one has to be able to interpret that late agreement as clearly intending to supersede. Now, of course, my learned friend has the points that this covers the same insurance between the same parties in the same year. But to stop the inquiry there on implied rescission is to fail to take into account all of the other points that we rely on as a matter of interpretation, that we say means that the implication, the unequivocal implication, that that second agreement was intended to just get rid of the first agreement, just simply isn't there and can't be found in this case.
Yeah, but the way it could be put is, what happens now, previously we had a set of words, meaning of which was determined by English law and covered the matters in question. We now have a set of words to be interpreted by a different law and a different body, and that governs it in the subject matter. And if you've got two agreements, one of which is governed by one law, one of which is governed by the other law, which may or may not reach the same results as to what the words mean, isn't it the case that the second one is inconsistent with the first? You can't have a provision governing this assurance which is governed by English law and a provision which is governed by a different law.
Yes, precisely. But the inquiry is not simply, and we say this is a point where the judge went wrong, the inquiry is not simply to say, are there two different governing law clauses? I mean, strictly we're concerned with arbitration and jurisdiction rather than governing law, but are there two different clauses that contradict? And if so, one rescinds the other. It's a question of, we say, whether the agreement, the second agreement, as it's referred to by my learned friend, rescinds the first. And in order to decide that, one needs to look at the two documents in full, one needs to look at them in context, and one needs to say, was the intention, was the unambiguous, unequivocal intention here by issuing this second document to just simply get rid of the first?
Well, also two stages. What do they intend with the second document? That any obligations they have will be such obligations as are recognised and enforced under New York law. And then the next question is, if that is what they intended in the second document, but they still then have intended something quite different, which is that they'd be subject to obligations as interpreted and enforced in English law.
Well, I think, my lord, that presupposes the point we're making, which is that that second document did intend that there be enforceable obligations governed by New York law. But we do say that it does need to be viewed in the round. One needs to view the entire document in its context against the first document in its context. And what I will hopefully come on to show when dealing with rescission is that the bar is high, and that in the absence of an expression by a party that this second document was in fact intended to supersede, that we say that that is not easily or readily read in. And so one then comes back to the interpretation argument, and we say, looking at the two documents, it's clear that one is a certificate and one is a policy.
And therefore, in the previous year, this is an extrapolation from where you are, in the previous year, actually it wasn't necessary to make it express that the MRC had priority because it's obvious if you look at the documents, is what you're saying.
Exactly.
So you're saying all of that was verbiage last year and we didn't need it.
Yes. It was simply, it was there, we say. And of course, I have in mind the section from Lewison, the interpretation of contracts, that arguments based on verbiage rarely find favour with a court. But we say that it was simply there to make the position clear, but it wasn't necessary. And it wasn't necessary for two reasons. My lady, I'll come on to one of those, and that is that we say that there is a contract, there is a clause in the captive policy, which is itself a clause in the MRC, which specifically says what certificates do. Now,
Just before you get to that, is it part of the background that this form of document, that's to say the MURA, is the form which you use in the American market if you want to make a contract?
I don't think that is
Why not?
part of the agreed background. I think that my learned friend's client's evidence was that contracts of reinsurance are agreed on that form in the US.
Sorry to interrupt, but my learned friend's client's evidence is to that effect as well. I'll just give your ladyship and your lordship the reference. It's in the supplemental bundle, tab 13, which is named with Gilman, who was broker of Thistle. And he deals with the US market at pages 175 and 176 of that bundle, paragraphs 9 to 13, and indeed says that it is practice in the US market just to use the MURA to create binding contract of reinsurance.
Well, that's what I'd understood the evidence on both sides to be, although, of course, the claimant's, appellant's evidence is that that's not relevant because this was something done in the London market, you say. But so far as the point I put to you is concerned, I'm not sure there is any dispute, is there?
My lord, I will check that. Certainly, I suppose that the point that we say is that insofar as it's suggested that the MURA is the contractual document, it's not suggested, I think, that it is the contractual document alongside an MRC.
No, oh no.
So I suppose I'm not sure how far that gets us, even if it is agreed. But I will have another look at Mr. Gilman's statement.
Thank you.
My lady, my lords, I think I was on point 2 of my 4 reading together points. So first is that the facultative certificate doesn't say on its face that it's intended to amend. We say that is a glaring and an important omission, because if my learned friend's primary case is right, it was intended to amend or supersede insofar as inconsistent. But it doesn't mention the MRC at all. The second point is that comparing the two documents, the MRC is clearly the policy of reinsurance. The facultative certificate is not. We will go through the documents now, but the MRC is a complete policy of reinsurance. It contains key clauses which are fundamental to the operation of the reinsurance that are not present, either directly or by incorporation, in the facultative certificate. The third point is that the MRC contains clauses which are specifically negotiated between the parties so that they can be considered bespoke. And in particular, it contains the communicable disease endorsement from partner Re. That was negotiated to be part of the MRC and only part of the MRC. It is not part of the facultative certificate. And so one can say, well, looking at this, if the parties are putting their negotiated clauses in the first document, then that, we say, is a strong indicator that that first document is the primary document. The fourth point is that we say that the parties have themselves agreed in the context of this contractual structure that certificates are solely for information, and that is by virtue of a clause in the captive policy, which I will come to. Now, we say that when those 4 points are read against a further 3, as I call them, buttressing points, the first is that in the prior year, the same form of document was endorsed and specifically noted to be subject to the MRC. Now, I appreciate that my learned friend says, well, if you say that in the first year and you don't say it in the second, then one might suggest that you intended it to be different in the second. But our point is that it was just for clarification in the first year, and in the second year it was unnecessary. The second point is that it's not disputed that the MRC is, in the London market, the contract of reinsurance as a matter of London market practice. We say it having been issued, it is therefore the document one would expect to look at in order to find out what the terms of the policy are, including the jurisdiction and the governing law provisions. And the third point we say, by way of background fact, which is not made good by reference to the documents because it's really an absence of documents point, is, I understand it also not to be disputed, that there is just simply no discussion or negotiation about the fact that when the facultative certificate was issued, it was intended to essentially rewrite the parties' bargain. And that, we say, is relevant also to business common sense, which we'll come on to. So turning then to the captive policy, this is at Core Bundle, tab 9, and it starts at page 100. So this is the policy between my client and its insured, Tyson Foods, which is incorporated into the MRC by reason of its incorporation into the Beazley policy. Now, one point I want to make is that one can see at page 104 the coverage, and there are then listed at A to, I think, J over the following pages what the policy covers, and it's real and personal property, consequential loss, newly acquired property, fire brigade charges, debris removal, business interruption, etc. Now, a point that we say is relevant is that the insuring clause, what my learned friend relies on as the insuring clause in the facultative certificate, refers only to direct physical loss as insured in the captive policy. Now, clearly the captive policy doesn't just insure direct physical loss, and there isn't in this policy the type of clause sometimes one sees that deems, say, business interruption or time clauses to be physical loss. Whereas the MRC does recognise that the underlying policy is in respect of more than just direct physical loss. And given, of course, what is being reinsured is this policy, we say that is a factor. Turning then to page 122, this is the clause I mentioned just now. And I should note as well that this has an arbitration clause and is subject to the law of Arkansas.
Yes, and that's at the previous page, and it's clause 24.
It is, Michael, yes.
And so the main captive policy is subject to an arbitration clause in Arkansas.
Yes, it's Arkansas law and an arbitration clause. I can't quite remember if it specifically requires Arkansas or just the United States for the arbitration, but I can check that.
So where does it say Arkansas in paragraph 24?
It's the governing law clause.
All right, which clause is that? 38.
Further on, I'm grateful.
Arkansas, yeah.
But, my lady and my lords, the clause I wanted to look at was clause 33. Now, this clause was not referred to in my skeleton. I wrote to my learned friend on Monday afternoon saying that I wanted to draw the court's attention to it. My learned friend has produced an additional authority, an extract from Edelman, Reinsurance. I'm not sure if that has made its way up to you already, but perhaps it might be convenient to pass that up. I may have to deal with this more fully in reply, but I'll cover what I think are the points being taken against me now. My lady, my lords, paragraph 33 is headed Certificates of Insurance, and it provides that any certificate of insurance issued in connection with this policy shall be issued solely as a matter of convenience or information to the addresses, or I think there should be addressees, or holders of said certificate of insurance, except where any additional insureds or loss payees are named pursuant to the special provisions of the said certificate of insurance. In the event any additional insureds or loss payees are so named, this policy shall be deemed to have been endorsed accordingly, subject to all other terms, conditions, and exclusions stated herein. So, we say this is relevant in two ways. First, because this clause, we say, is a clause of the MRC. It's therefore a matter of agreement between the parties.
It's a clause of the MRC.
It is, my lady, yes, by virtue of the fact that this captive policy is part of the Beazley policy, so the original policy wording, and the original policy wording is incorporated into the MRC. And I will, when I'm looking at the MRC, there are two places where that is made clear. So, my lady, my lords, the first point we say is that this is a term of the captive policy, and it is a term of the MRC, and it provides that the parties agreed that certificates were for information only. So what my client's case is reflected in this clause.
So you have to have a certificate. It says that if you have a certificate,
Yes.
then it's solely a matter of convenience. It begs the question as to what the document, the next one is, but yeah, okay. But if you have to have one, then it's for convenience only. Sorry, if you have one, it's for convenience only.
Yes, my lord, and I will come on to address why we say this is a certificate, the facultative certificate. So that's the first point, is we say that it is a matter of agreement. The second point we say is that even if it's not directly binding, it is a background fact as part of the relevant contractual matrix as to how such documents are viewed in the context of this reinsurance. And I'm not sure it quite qualifies as a point on its own as point 3, but as an aside, the rhetorical question that my learned friend asks, and it was also put to me by my Lord Justice Males, as to, well, what is the certificate? Well, this explains it's for information only. Now, I think two questions arise on this point. The first is that which my Lord Justice Lewis raised, which is, well, what is a certificate? And the second is a point of incorporation, which my learned friend takes. So, was this incorporated into the MRC? Now, taking the first point, we say that clearly the parties thought that this document, the MURA, was a facultative certificate, and therefore is a certificate within the meaning of Clause 33. In the communications between the parties, it is only, as far as I can see, referred to as a certificate. It's referred to as a fac cert, a facultative certificate, an RI cert, which I think is reinsurance certificate, but it's never not a certificate. So we say that the parties clearly called it a certificate. We also note that the originating statement in the Section 9 application from Mr. Metz, on behalf of the respondent, also defines it as a facultative certificate. So it doesn't seem to be an issue between us as to what it is. What's an issue between us?
Hold on a moment. If you're looking at the objective intention of the parties, do we just look at a couple of emails sent before, or don't we have to look at the document as well? You can't approach the document by reference. Can you solely to what two parties said in emails?
No, and one obviously has to look at the document as well. And I suppose simply because the parties called it a certificate doesn't necessarily mean it is a certificate, but it is a fact to be brought into account. And we say that this is a fact that was expressed on both sides of the fence, as it were, both before and after.
It clearly wasn't responsive to be in paragraph 33 because it wasn't for information only, because I thought the premiums weren't going to be paid until the document that we're calling certificate was issued.
Well, that, my lord, we say is an administrative provision. That doesn't elevate it to anything other than a summary of cover, a certificate for information only.
It's not for information only, it triggers a legal event, payment.
Well, I think there is a fine distinction here, which is that the obligation to pay is not impacted in any way, we say, on my case, by the certificate. The obligation to pay finds itself in the MRC. The administrative process of payment being made is what we say is triggered by the certificate. So it's like, for instance, somebody saying, well, can you send me your purchase order number and then I'll make the payment?
Would there be a breach of the MRC if you hadn't made payment before the certificate was sent?
So would there be a breach if payment hadn't been made before the certificate was sent? No, unless the date that was provided for in the MRC had passed, in which case, arguably, yes. And one
The
might...
date in the MRC, was it the certificate or a different
I
date?
think it was the 28th, I think of.
The 28th of September in the MRC and the 1st of September in the Euro.
So,
But you also, sorry to interrupt you, you also asked us to take into account what was said by Mr. Metz in relation to Section 9 application. That's long after these events.
yes, it is.
Yeah.
It is. But it shows, I suppose, that what it's referred to by the parties, what it's known as in the market, what the document is a certificate, a facultative certificate. So, I'm sorry, I think I was just completing my answer to your question, my lord, but I think the point would be that if there were no payment by the 28th, that would be a breach of the MRC. There might be a fight between the parties to say, well, you never sent the certificate, so the payment was never processed, but whether that would be good in law or not, it's happily, I think, not something we need to get into. But what we do say is the obligation to pay comes from the contract itself, the MRC. And the fact that money moves once the certificate is sent is really neither here nor there, certainly not enough, we say, to elevate it to a contractual document. Now, I understand my learned friend suggests that the certificate clause is not incorporated, and what's relied on is paragraph 3.4.6 of the extract from Edelman that has just been handed up. Now, Mr. Edelman sets out there a summary of the, from memory, I think, very lengthy judgment of Mr. Justice David Steele in HIH Casualty as to when incorporation of specific terms from an underlying policy can be achieved. Now, Mr. Edelman says a specific term can only be achieved if, and then gives 4 principles. Now, if Mr. Edelman there was intending to suggest that this is some sort of mandatory test, then we disagree. It's a question of construction. They are, however, helpful guidelines, and we do accept that they're relevant and that the court ought to look to them when determining whether there's been incorporation. But we say, I suppose in very brief, that all 4 of those requirements are met in this case. The term is apposite for inclusion in the reinsurance because the term can, with either very minimal or no manipulation, be read into the reinsurance. One only needs to read reinsurer and reinsured instead of insured. We say, sorry, that was point 1, that the term makes sense. Point 2, that the term is apposite. We say it's apposite because, as a point that's made against me by my learned friend and a point that the judge made, certificates were always intended. They were included in the prior year. Their issue was heralded before the contract was concluded. And at the time that the MRC was stamped, it was said they would come through at some stage. So of course we say it's apposite to have a clause dealing with the status of certificates in a contract that envisages a certificate being issued.
Well, we've gone through this. It didn't envisage a certificate being issued. It said if a certificate is issued, it's for information only. It doesn't tell you when. And we're talking about one thing here, that certificate will be issued.
I'm sorry, my lord, perhaps I wasn't clear. I wasn't talking about clause 33, but the contract as a whole.
Oh, right.
And the test is whether clause 33 is apposite to be included in the insurance. And so I'm talking about the MRC. And
Right, okay.
my point is that the contractual scheme between the parties that was always envisaged was that it would be a scheme that involved a certificate being issued. Now that's a point taken against me by my learned friend, and it's a point that the judge said supported the view that the certificate was intended to supersede because it was always intended to be issued. Now,
It's my fault, I'm being slow. If the source of the expectation, stroke obligation to issue a certificate is the MRC. Where is it in the MRC then?
My lord, it's not in the MRC itself. The MRC doesn't say it's being issued. It's the fact that the parties said prior to the MRC being agreed that facultative certificates would be issued, and then second, that at the time that the MRC was stamped, it was said fact certs will follow at some stage.
So what document are you saying reflects the expectation of the parties that provides the necessary link between 433 and the MRC? Is it just the emails that we've looked at, page 164 and so on?
So it's the two emails that I've referred to, and it's the background fact that in the prior year, that is the process that was done.
You say two emails, I've got 164, just so that I haven't missed an email. What's the other email that you say shows what the parties' expectations were?
These are it's in the supplementary bundle. The second one in time is at page 51, tab 4. I'm sorry, that's the prior year.
Oh, that's the prior year, okay, yes.
It's page 160, supplemental bundle, tab 7. And this is a point taken against me, I should say. 3rd of June 2021, 1526. This is an email from Nick Whitcomb, who is at Lockton, my client's broker, to Mr. Hennessy, who is Partner Re's underwriter. And the final bullet point says, programme will remain as Reinsurance of Tyson International Company Limited captive, and we will provide reinsurance certificates and the updated policy form in due course.
Sorry, it's entirely my fault. I thought you said tab 4 and tab 10. I don't see what you've just read out. Did I just tab 4 or tab 10 in supplementary bundle? I'm really sorry.
No, I'm very sorry. I'm almost certain it was me being unclear. It's tab 7 of the supplementary bundle, page 160.
Right. No, I've got it. I'm so sorry.
Not at all. And so it's that final bullet point in the body of that email. And the second email is at tab 9, page 163, which is the 30th of June 2021. And so this is an email that's sent in response to the MRC having been signed. And it says fact certs will come through at some stage. Now, the judge relied on those two emails as suggesting that because it was always intended that certificates would be issued, the intention was that the certificates would supersede. Now we say, in the context of clause 33, and whether this clause is apposite to be incorporated, given the structure of the agreement between the parties, which is a policy followed by a certificate, it is of course apposite to have a clause dealing with the certificate.
This clause 33 deals also with the question of amending the policy by adding additional insurers or loss payees, and it provides provisions about deemed endorsements. So there may be a question, I suppose, whether that is consistent with the change provisions in the MRC, because I've been trying to find them, but I can't at the moment. But if they provide a different procedure, that might suggest that this clause was not intended to be incorporated, or is not apposite, because it's then providing an inconsistent way of changing the contract.
Of course. I think the answer to that is twofold. One is that it's not inconsistent with the change provisions. So all it says is that it shall deemed to be endorsed, but that doesn't mean that it is endorsed in a different way to the GUA. So my primary case would be that the endorsement would still need to follow the GUA procedure, and it would therefore be done in that way, and it would be part of it. My alternative case, my lord, is that...
Well, if it's only deemed endorsed, it doesn't have to be endorsed, surely. That's the point of deeming.
Well, and so I suppose then I fall back onto my second submission, my lord, which is that insofar as it varies the endorsement procedures, under the GUA. It does so only in that very limited sense that it concerns additional insureds and loss payees. So that doesn't undermine the fact that any other type of endorsement needs to be done in accordance with what we say are the clear contract change requirements in the MRC. So my primary point is not inconsistent, but if you're not with me on that, my lords, we say that it's limited in scope.
Thank you.
So I think I was on opposite point 2. Point 3 is whether it's germane to the reinsurance. Now, we say it's germane in the sense that it goes to whether further insureds can be added. So this is related, I think, to Lord Justice Mayall's point. It does have a function. It has a function both in the sense I've relied on, the apposite category, but also in a wider sense as to in terms that it operates in the functioning of the policy. So it is, we say, the sort of clause that one should have no problem incorporating in. The types of clauses, as Edelman notes, which the courts have had issues incorporating, are clauses which they say are personal to the parties. So things like jurisdiction and choice of law. But clauses that go to the operation of the policy, we say, fall squarely within those which can be incorporated. And then finally, my lord, whether the term is consistent with the express terms of the reinsurance. Well, we say it is consistent with the express terms of the reinsurance because there is, in this case, nothing that contradicts it in the sense that there is nothing that says a certificate is otherwise, and that's what this is really going to. So, my lord, my lady, I think that's all I'll say at the moment on that point. There may be some other clever point that I've not spotted that my learned friend makes that I'll have to reply to, but I think that covers the ground. We were, I think, in the documents and back in the core bundle, tab 10, we were in the policy, and I wanted to move to tab 10, which is the next tab along, which is an endorsement to the Beazley policy. Now, as I said, this is incorporated by reference into the MRC.
I'm sorry to rise again. I don't know whether this matters. Our understanding is that this is an endorsement to the captive policy. That forms part of the captive policy. I'm not sure that that's significant, but I thought I'd make the point in case there's any concerns on it.
Of course, so I'm not sure that anything significant turns on it. I don't think that's the case because I think that the policy number 3094 is the policy number of the Beazley policy. Now, there was something said in the judge's judgment, and to be fair, I think he was led astray slightly by Mr. Gilman, that the policy number of the MRC is the same as the policy number of the captive policy. I don't think that's right. I think that if one was reading very quickly, one might get confused between the two numbers, but I think the difference is that this is 3094, and I think that the MRC that we are dealing with is 3490. So they are frustratingly similar,
Yes.
but not the same. But the point I want to make is a point that is valid whether it is an endorsement to the captive policy or an endorsement to the Beazley policy, and that is under A, under limits of liability. It's stated there that the companies, and this is why I think it might be the Beazley policy, because I think this might be a reference to the primary layer insurers, shall not be liable for more than its proportion of, and then the typed section is as stated in the risk details section of the market reform contract. Now, I don't want to put too much weight on this point, but we say that is yet another factor to weigh into the mix to show that when one is looking for where the obligations of the parties lie, one is expressly looking at the market reform contract. And that is said, we say, in this endorsement. I think, my lady, my lords, it's then time to move to the MRC itself.
Before you do that, what's the date of this? I see lots of dates. I see it effective 1st of July 2021, so I assume it's for the new policy, the one that we're dealing with. But I see lots of other dates and I don't see a signature.
So I think its effective date was the 1st of July.
Yeah, it says that.
I think that it was agreed at around that time, because my understanding was that the Beazley policy was essentially the first policy to be agreed. It was the first layer. I don't know precisely when it was.
The expectation is it was agreed shortly before it became effective.
It is the expectation, but I'm afraid I can't confirm either way. And I think the other dates, my lord, are just dates of the standard form clauses. So there are some LMA clauses and the date below those. So for instance, on page 144 above communicable disease endorsement, LMA 5400 11th of November 2019, that's just the date of that wording, I think.
So it was agreed before the Mura came on the scene with its many pages rather than its 2 pages.
My junior, Mr. Partridge, tells me, because he has a much better memory than I do, that he thinks it was agreed on the 5th of July. But I'm not sure there's anything in the bundles here that shows that. I'm very sorry, my lord. I think you asked me a question, and I'm not sure I have.
No, because if it was before the 1st of July, it would have been before Mura in its expanded form with 2 pages of quasi-certificate type material and 8 pages of terms and conditions. And I was wondering whether it makes sense for it to refer to the market reform contract at a time that Mura was not yet even the twinkle in any insurer's eye. But you tell me it was the 5th of July, and by then the gestation period may have been underway, I don't know.
Well, I'm not sure that makes an awful lot of difference in circumstances where I don't think it's disputed between us that it was at the outset envisaged that certificates would be issued. The point I make, really, and as I said, I don't want to put too much weight on it, is just simply that this is clearly a part of an endorsement which wants to refer or does refer to an operative part of the reinsuring agreement. And when it does so expressly with reference to the market reform contract.
But why is this relevant at all to the contract between Tyson Insurance and Partner Re?
Because
especially as we're now told it's agreed after that contract, the market reform contract, becomes effective.
Because, my lord, this contract is part of the market reform contract agreed between my client and Partner Re.
Well, not if it's agreed after that contract comes into being. I take your point that the Tyson Partner Reinsurance market reform contract incorporates the Beazley contract, but surely it doesn't incorporate endorsements to the Beazley contract which have not yet been made.
Well, I think our position, my lord, is that it incorporates them as amended, and certainly my learned friend relies, as I understand it, on the communicable disease endorsement at page 144 of this endorsement as being part of the contract, because one of the points that we make, and already my lords will have seen that, is that we say that there is a bespoke communicable disease endorsement in the MRC, and that we say is jettisoned if the MURA, the facultative certificate, takes precedence. My learned friend's answer to that is to say, well, there is a communicable disease clause in the captive policy, which is therefore part of the agreement between the parties, part of the facultative certificate. And that communicable disease endorsement is part of this endorsement. So I don't think it's, my learned friend will tell me otherwise, I hadn't understood it to be an issue between the two of us, that this was part of our MRC by virtue of incorporation.
I mean, incorporation, as we'll come to, does refer to endorsements, but I'd assume that meant to date, but you say it means including future endorsements.
Well, my lord, perhaps I can be equivocal on that point. As I said, I'm not sure that I'm saying, I don't want to put too much weight on this. It was meant to be more of a passing reference as we cantered through, but I can see I've got bogged down, so I'll move on, perhaps.
Before we move on, I just want to be clear as to what my friend is saying. My understanding is that the reference to the market reform contract at A on page 142 is not our market reform contract, but the Beazley market reform contract.
Yes.
Yes, of course.
Yes.
So,
at best, this reference is just a reference to show that generally parties, I'm just putting it your way, generally parties refer to the MRC as if it were the hub, put it
Yes.
that way.
precisely.
Doesn't mean anything more than that.
No.
So let's go on.
Thank you. My lady, my lords, I wonder, it's 10 to 12, that might be a sensible time for a short break for the transcribers, just before I get into the MRC itself.
Have you factored in your time table breaks?
We had. I'm not.
Because I'm not in favour of breaks personally, but
Understood. Well,
we will rise until 5 to 12.
I'm grateful. think we'll get there.
Mr. Killen.
My lady, I was just about to come on to the MRC itself, which is at Core Bundle, tab 11, page 146. Now, I'm going to go through it, but I think probably a relative, given where I am in my notes. Now, we say that the MRC is and looks like a policy of insurance. It has a policy number on its front page, PRPNA 2103490, and one then goes over the page to page 147, and one can see that there are the risk details that are added in.
And there's no doubt that it is. If there'd been no MURA, it's accepted, this would have been a contract.
Yes. But I suppose it's the relative point, my lord, that we're going to come on to, which is that this is very clearly a policy of reinsurance for this for this risk, whereas we say the facultative certificate is not. There are also, and I'll point them out, and this is really the main reason for me going through these, some of the clauses which find themselves here in the MRC, but do not find themselves in the facultative certificate. And we say that that is a relevant argument. It's the same argument I made before the judge at first instance. He referred to it as sweeping away. My point being that if you have the facultative certificate taking this in, well, then you lose quite a lot. You lose quite a lot of important clauses. And so one then has to look at this and step back and say, well, can the parties really have intended to do that? Did they really intend to agree these clauses, these bespoke clauses, these clauses that went to the operation of the reinsurance, and then just get rid of them at some indeterminate point in time later, 8 days in this year, 30 days, 29 days in the prior year? And we say no, and we say that that is part of the process of interpretation. Now, just very briefly on page 147, the original insured is referred to as Tyson Foods, and that refers to the original policy wording. That is, as we'll come on to, a reference to the Beazley MRC incorporating the captive policy. One can then see the address, period, interest, and sum insured situation, and one then comes to conditions. Now, at conditions here, there are a couple to draw the court's attention to. The first is policy wording, and that provides, and this is one of the two ways that we say that the Beazley MRC, along with the captive policy for my clause 33 argument, is incorporated. It says here, policy wording, LPO 384C MRC amended, excess physical damage form, following terms, clauses, and endorsements of the original policy wording, being policy number PRPNA 2103094, issued by certain underwriters at Lloyd's. So that, we say, is one of the two ways, one of the two places where that wording is incorporated into this policy. There's also here then a list of the conditions that have been agreed between the parties, and we'll see there is an email from Mr. Hennessy of Partner Re to Mr. Whitcomb of Lockton. In fact, we may as well turn to it now, so I don't need to go back to it later. It's in the supplemental bundle, tab 8, page 161. that has, at the top of the page, it says attachments, and it attaches a PDF, which is PRE, which is partner re, communicable disease exclusion. And this is then the offer for what will be insured on the various layers. And on the next page, 162, are a list of clauses that partner re, we say, wish to see in the policy. So authorisation is subject to the following conditions. It says, unless otherwise contained in final slip/policy form to be provided. And my learned friend relies on that to say, well, that meant it was conditional on what the final slip says. But we say that it's important here that this was a clause that was specifically asked for, and where it went was in the MRC and not in the facultative certificate. And one can see a list there of clauses, some of them standard form London wording, but the second bullet point, pre-CD exclusion as expiring, and that's a reference to the partner re communicable disease exclusion that was attached to this email. And it's said to be as expiring because, as we'll see, it was also required to be in the prior year's policy, where it also was added into the MRC, but not into the certificate. Now, one might say that if it said as expiring, that suggests that it's still in force. And it's still in force, we say, because it wasn't in the prior year superseded by the facultative certificate. So that either lends force to my general point that the certificate doesn't supersede, or to my specific point over which there's also dispute as to whether the endorsement on the prior year was in fact a hierarchy clause that provided for the MRC to take precedence. But we'll come on to that. So we have that at conditions, which is the at 149, partner re communicable disease exclusion. It is 1, 2, 3, 4, 5, 6 lines down.
No, I'm sorry, where are you now? You're back in the other...
I apologise. I'm back in the core bundle at tab 11.
Yeah. At 149.
At 149. But I'm sorry, just before we go there, at 148, there is also a condition that agree, if required, to allow agents to issue certificates and or verifications and or evidence of insurance without advice. My Lord Justice Lewis.
Where is that?
It is 148, and it is about 7 clauses down.
11 lines down under conditions. Left-hand side starts agree.
Oh, yes.
Now, I'm not saying that that is, again, something that says certificates will be issued, but, my Lord, you asked me where certificates were mentioned. I think that is the only place in the MRC. Continuing then, choice of law and jurisdiction, I'm sure will have been seen. 2 points to make very briefly on it. That's at page 149. 1, choice of law and jurisdiction are in a single clause. And I'll come on to that in the context of the reading together argument that my learned friend makes. 2, we say that the jurisdiction clause is A, exclusive, and B, broad. So hereto on all matters relating to this insurance. And it's this insurance, meaning the insurance in the MRC rather than just this contract or some other narrower wording. Page 150, insurer contract documentation, is also relevant. I'll refer to this now because it forms part of the contract change argument. This says that the document details the contract terms entered into by the reinsurer and constitutes the contract document. Any further documentation changing this contract agreed in accordance with the contract change provisions set out in this contract shall form evidence of such change. So 2 points. 1, this document is expressly professing itself to be the contract document, not the rather broader an agreement wording that is in the facultative certificate, but the contract document. So we say that is relevant in the interpretation of the 2 documents. The second point is that we say that that clause, and certainly read with the contract change provisions, which we'll come on to, makes clear that changes are required to comply with the contract change provisions.
I want to address the first argument. Is the second document a variation of the first? But if in fact the second one is an implied rescission of the first, then the fact that it's not done by the form of amendment makes sense, because it wouldn't be done by the form of amendment because it's not amending it. It's rescinding it and setting out a new set of terms governed by different laws.
Well, I suppose, my lord, one of the points I'll make is that if it's simply, so if you're with me that there are contract change provisions that have to be followed, then we say that significantly narrows the scope for a rescission, an implied rescission argument. And I'll take, my lord, to the MWB and Rock advertising in the Supreme Court, which we say makes that clear. The idea that parties who bind themselves, and if you're with me on that first stage, bind themselves to a requirement that there be a particular form followed in order to change, cannot then just simply unbind themselves on the basis that they're sovereign by agreeing a new contract or a new form that doesn't follow the amendments. But I'll come on to that, my lord. Moving on down, one then has the clauses printed in full into the document, and one then gets to 157 is the next bit which I wanted to draw attention to. I should say that those clauses that we have skipped past now, they are themselves in the captive policy. It's a point my learned friend makes. He says, well, because we refer to the captive policy in the certificate, those clauses are included. Accept that. What we say is that if you're looking at the two documents and which one's intended to be the policy of reinsurance, it is more likely to be the document in which they are printed, and the parties have specifically gone to the bother of printing out the clauses, rather than just simply referring to them. But we get to excess physical damage form, which is at page 157, and this is not in the facultative certificate. And these are, we say, important provisions. The first is the insuring clause, which we say is a rather more detailed and rather more specific insuring clause than the insuring clause in the facultative certificate. 2 is the application of underlying provisions. This is the second way by which the captive policy and my clause 33 point are incorporated, because it provides that in respect of the perils hereby insured against, this insurance is subject to the same warranties, terms and conditions, except as regards premium and the limits of liability, other than the deductible or self-insurance provision where applicable, and the renewal agreement, if any, and except as otherwise provided herein, as are contained in, or as may be added to the insurance of the primary insurers prior to the happening of a loss for which claim is made hereunder, and should any alteration be made in the premium for the insurances of the primary insurers, then the premium hereon may be adjusted accordingly. Now, my Lord Justice Mayles asked me a question as to how the endorsement to the policy, if it was added afterwards, might follow. I think this provides the answer, which provides that it is as may be added to the insurances of the primary insurers, and the time at which the endorsement being added is relevant is prior to the happening of a loss. So I think, my Lord, that addresses your concern.
Yes, thank you.
There's then a limit provision which provides that the underlying insurers must have paid out, so that's the 75 million for Beazley in this case. That's not in the facultative certificate or in the captive policy. Then there's the maintenance of primary and underlying excess insurance and limits. Again, we say an important clause in the functioning of the reinsurance. That is not in the facultative certificate. There's then the uncollectability of other insurance, 5 over the page on 158. Again, not in the facultative certificate or captive policy. Likewise, the application of recoveries. There then is at page 160, just at 159, there's a strike through of parts that were thought not to be relevant. Again, not a particularly weighty point, but we say it shows that it's being amended, it's bespoke in that sense. The underlying insurance identification, this makes clear, we say, what the underlying policy is, and the incorporation points for the 2 parts that I've referred to already, because it identifies the primary insurers as being certain underwriters at Lloyd's, and the policy number is being PRPNA 2103094, and that is the Beazley policy number. That's the number we saw on the endorsement. And so that, we say, makes clear that that is what is being incorporated. At 161 is a time element extension. Now this, we say, dovetails with the captive policy and makes clear that the reinsurance is not simply for physical loss. Whereas when we come on to the facultative certificate, we'll see that it does only say or purport to reinsure in respect of direct physical loss. Whereas this policy recognises the nature of the underlying captive policy. There is then at page 168.
What is it that this policy or the captive policy insures over and above physical loss?
So it's physical loss, and then it's all of those others at A to J that we saw in the captive policy, and it includes things such as fire brigade cleanup expenses, business interruption, time elements extension, stock in trade, and the like. So I suppose some of those there might be an argument as to whether they're direct physical loss or not. Business interruption, we say, is one that isn't.
Well, I think it was business interruption, which is a consequence of physical loss.
Yes, yes. But there isn't, as one sometimes sees in policies that refer only to direct physical loss, a deeming provision that deems business interruption or time element extension to be direct physical loss. So we say again, this is another indication that the MRC properly reflects the underlying insurance that's being reinsured. Page 166 is then the communicable disease exclusion, and this is, again, the bespoke wording, the wording that we saw from the email just now, that was sent to my clients and said to be incorporated. Over the page at 167 is a claims control clause, which also provides, again, we say, an important right for an insurer, a reinsurer, to have the right to appoint adjusters and representatives to act on their behalf. That does not find itself in the facultative certificate. Over the page at 168 is the reinsurance payment of premium point that came up when I was discussing with my Lord Justice Lewis earlier, where the obligation to pay premium came from. And then page 169 is the subscription agreement. And I think for reasons of efficiency, we'll look at this now, but it's relevant to the contract change point. The slip leader is partner reinsurance, the respondent. The basis of agreement to contract changes, which is what was referred to in the clause under the risk details in the conditions section, is outlined here as being all changes to be managed and agreed in accordance with the General Underwriters Agreement version 2.0. We will go to the General Underwriters Agreement under the discussion of the contract changes, but I note for now that this clause says all changes. So we say, again, it supports the view that if it's to be a valid change, it must comply with the GUA. 177 is another clause that it doesn't find itself in the facultative certificate or the captive policy. That's the reinsurer's liability clause. And again, we say, in a situation where there is a wide programme, albeit I accept there is only one reinsurer on this 10% of this layer, that provides that there is to be several and joint liability with other reinsurers. Again, we say another factor weighing in to this policy. And then 180 is just the signature page, which makes clear that what's written is 10% of the whole, and that's signed by Mr. Hennessy. And of course, each page of this is stamped and signed as well. My learned friend makes that point in relation to the facultative certificate, but we say that really is a score draw, if anything, given both stamped and signed. Turning then, so comparing that, what we say is a full policy of reinsurance with a number of terms that are not in the facultative certificate, important terms for the reinsurers. We then get to the facultative certificate, which is at page 181. And in the middle of that page, coverage.
Well, before that, I mean, you keep saying the facultative certificate because there's an email referring to it, but the document bears the title Agreement Number and Agreement of Facultative Reassurance. So I know you're saying that this is a certificate, but it's important to bear in mind that if we're looking at how the parties described it, they didn't describe it as a certificate. If that's relevant, that's how they described it.
Well, I suppose I wouldn't quite agree with that. The parties described it as a certificate whenever they talked about it.
No, in this
The document
not in the
itself,
emails, that's what I'm saying.
and I accept that. The document itself does not describe itself as a certificate.
In what sense is this, on either party's case, facultative?
Well, I think it's facultative because it's reinsuring a particular risk rather than just a treaty. So I think it's facultative in the sense that it's not treaty reinsurance, I think is the distinction.
I mean, from my dim recollection, facultative reinsurance is where you can choose which risks to apply to the reinsurance. Have I got that wrong?
So my understanding, my lord, at least, was that facultative reinsurance was reinsurance of a specific risk, which might include a particular policy. But the treaty reinsurance was one where one might say, I will reinsure your motor business. And so all of your policies that you take into the treaty are then reinsured by the treaty. So I think because this reinsures the captive policy, I think in that sense it's facultative.
Okay.
My learned friend may have a different view.
I agree with that. And my lord, I think the type of cover that you're referring to is often referred to as an open cover, where the insured has an option to declare risks to the cover.
Yes. Okay, well, if it's not I only wanted to understand it, it's not likely to be crucial, but anyway, there we are.
I don't think it is, my lord.
Good. Thank you.
Well, page 181, coverage. This is the point I was making earlier. So all risk of direct physical loss or damage as per the policy reinsured. Now, on one view, that doesn't refer to business interruption, doesn't refer to the time owns extension. Well, given that's the policy that's being reinsured, one would have thought that that might be a deficiency. And so again, something we say to weigh into the balance. I should note that at the top left of this is the...
Sorry, so what do you say that does mean? Now, on your case, this is a certificate which is administrative only, but it's got a reference to a risk which is different from the MRC. So do you just ignore it?
No, it's just shorthand. It's shorthand for what's there. It's not, we say, as full as the MRC. It's not describing fully what is being reinsured. It's just simply saying in short form, this is the insurance you've got, which we say plays into the fact of this being administrative for information. I should note top left is an agreement number. That is the policy number. My learned friend says that that is the basis on which this refers back to the MRC. Now we say that that is a slim foundation and a shaky foundation on which to build a case, that the parties intended this subsequent document to amend that first document. It doesn't say the master reform contract bearing policy number is hereby amended, varied, superseded, rescinded, or whatever it is. It just has the same number.
And they could say rescinded, and that would be clear, but I thought you didn't have to say it. It's all to do with looking at the context and the background and the party's information and this document to decide.
Yes.
And then you decide whether or not it rescinded impliedly.
Yes.
So simply saying it doesn't say it impliedly rescinds doesn't advance matters really. It doesn't expressly amend, it doesn't expressly rescind.
I take that point, my lord. I suppose my point is simply that it is inherently unlikely that parties having agreed a full contract of reinsurance would 8 days later intend to just simply get rid of it without saying so. That is my point. My lady, my lords, given the time, I'm going to let my learned friend take you through the clauses of the facultative certificate itself. We say that they are standard printed form clauses. The governing law and jurisdiction is New York law. There is the arbitration provision in there. What we point to is the fact that there are clauses from clause 27, page 188 onwards, that have, in brackets, if applicable, behind them. We again rely on this fact just simply to say that this is clearly a one-size-fits-all, not in any way bespoke, standard form contract terms which have been included within this document, which we say cannot have been intended to act as a contract of reinsurance, certainly not when compared to what we've seen in the MRC.
Well, what would help me? I mean, clearly, if you were only to start page 183, and if we were to look at the fact that these are not documents to be interpreted by English law, by an English court or a Welsh court, it's going to be interpreted by a New York arbitration body applying New York law. What on earth were they stamping and signifying agreement to? They were not providing certificate in pages 183 to 190 for information only, because the information is positively contrary, for example, choice of law and method of enforcement. So what would the reasonable person reading pages 183 onwards think that by this stage in the game the parties were doing?
Well, I suppose, my lord, I accept that if the reasonable person simply picked up this document and read it from page 183 onwards, they would say, well, these are the terms of an agreement.
Yeah.
But the point I'm making is we say that that is too simplistic an approach, and one needs to compare the two documents. One needs to look at what is in the documents in a relative sense. One needs to look at how bespoke those documents are. One needs to look at the underlying cover and which one reflects it. And our point is that when one does that relative exercise of looking at the two documents, interpreting the two documents, one comes to the conclusion that this second document is unfortunate in the sense that it has terms and conditions at the back of it, but they are not intended to be the terms and conditions of the reinsurance.
And as I said some time ago, your position, as I understand it, is that other than the front 2 pages, the rest of it is verbiage, and it's just unfortunate that it was there, a bit of a surprise maybe, and unfortunate that it was stamped.
Yes.
It was just a mistake, really.
Well,
The man with the stamp shouldn't have bothered. He should have stopped the picture. It's just surprising to somebody who's not an insurance lawyer that parties have sent this document. They've changed which law tells you what the words mean. It's all stamped and agreed. It made it look odd. We think, well, why did they bother doing that? They'd already had one on the 1st of July, and the answer is, well, this is a different one.
well, I think, my lord, is the answer is that certificates are a feature of insurance. They
This
are
isn't a certificate,
something
you
that...
see. This is a document, and because I don't know anything about insurance, and I read it and it's headed terms and conditions, and you can show me all the emails, I'm still left without coming to a code. Yes, they had this on the 1st of July, and it was the MRC, but there is something equally significant on the 8th of July, and it's totally different because it's done by a different law, which should tell us what the words mean. And can I just say that wasn't a reflection that they intended now to play baseball, not cricket?
Well, my lord, if that is your concluded opinion, that's obviously unfortunate for me. But we say what one needs to do is not simply look at that. One needs to look at the two documents in a relative sense. And my lady, to your question, is this just verbiage? My answer is that one might view it that way, but equally, well, then the MRC is just verbiage.
No,
Because on my learned friend's case...
The MRC was the legally binding agreement until it was rescinded.
Yes.
It covered the period, the 1st of July until the 8th of July. And if this had never been stamped and signed and agreed, it would have continued to do it. So that was never verbiage in the way that you say that this is verbiage. Because 183 onwards never had any purpose at all.
Well, my lord, I'll come on to the business common sense point now, so that I don't need to repeat it later. But my point on that really is to say, and I suppose we say it is verbiage, but verbiage of a different sort. Isn't it curious to pose the question that the parties would have agreed a contract by the MRC subject to English law, and all that entails, the Insurance Act 2015, the specific duties of fair presentation, the rights of the parties that are imported by reason of that, and then at some indeterminate point in the future, 8 days in this year, 29 days in the prior year, simply get rid of that.
Yes, because they wanted something different. They wanted a set of terms governed by New York law and enforceable in the States. As I said, they decided they didn't like cricket anymore. They wanted to play baseball. They stopped from having a set of words to be interpreted by one state's law and opted for, as a maybe surprising thing to do, but that on one reading gives some reason to it. Well, yes, they lose the communicable diseases bit. Yes, they lose other things, but they get a totally different option.
Well, my lord, of course, that option has to be viewed against the background that, first, we say it is surprising. Second, there's no discussion about it. And we say that's a relevant background fact. We say it is relevant when looking at it to say that it's surprising. They didn't discuss it. And third, when one looks at the two agreements, there's a primary agreement, clearly a primary agreement, clearly a policy. And second, an agreement which is broad, inadequate, doesn't include specific terms. And we say that that is what needs to be fed in. So, my lord, I accept that in an isolated sense, one might look at that second document and say that. But we say that in carrying out the iterative process of interpretation around, that isn't the case. My lord, I can see I'm very...
just ask, and I know that you're running out of time, the certificate the previous year, which was subject, and I know there's argument about that, to the priority clause, was it in the same form as this? With all the extra pages?
It was, yes.
Thank you.
There are differences, my lady, and I'll take to those
Okay.
in my submission.
Fine. Don't waste your time then. Carry on.
My lady, so moving on then from looking at the two documents, I also said that the MRC was inherently bespoke in the way it was created. Now, my lady, our point on that is we say that the way that the MRC is put together is that there are, as one can see, side headings, and then the data is inputted. And the reason we say that it's bespoke is because that data is specifically inputted. And so, for instance, the choice of law and jurisdiction clause was specifically inputted. And we rely on the canon of construction that generally, and we accept it can be overcome by express words or other conduct, but generally that the specific supersedes the general. And so we say in that sense, if one's looking at the two, the MRC is specific. Because of time, I'll just give my lady and my lords the reference, but in AIG and John D. Wood, Mr. Justice Jacobs had cause to consider the market reform contract. He set out that it was understood in the London market that all the documents are prepared up front, and when the underwriters scratch the document, the contract is in its entire form. Now, we say that's relevant because if one looks at this document and says, well, that's the document one would expect to find the terms in, then that's another factor to be put into the balance as to which document is the operative document. It's also the case, and I'm sorry, that's at paragraphs 49 and 50, but it's also the case that in that case the MRC contained a particular clause which Mr. Justice Jacobs accepted was specifically negotiated by reason of the way it had been inputted into the MRC, into the market reform contract. And that's at paragraph 103. Now, it's fair to say that in that case, Mr. Justice Jacobs didn't then go on to apply that specific clause over what he found was a standard clause later on in the same document. But the reason in that case was because that specific clause, which was a jurisdiction clause, didn't actually refer to a jurisdiction. It referred to a jurisdiction in the underlying policy, and the underlying policy didn't have a jurisdiction clause in it. So we say that's different. But the general proposition we take away is that the MRC is specific.
Did the Court of Appeal have anything to say about that?
My lord, I don't think on that bit, no. Or on the discussion of the market reform contract. I think your lordship might know better than me. Was that not?
Well, I know I gave the judgment in it, but I have no idea what it said.
But that is comforting. But I don't think so, but I can certainly double check. My lady, my lords, I made some buttressing points at the start. I think what I want to do is move on to the general underwriters agreement point and the change provisions. I think I've already set out my stall on why we say that the general underwriters agreement needs to be followed. The general underwriters agreement is itself at the core bundle tab 13. It starts at page 191. We might turn to that very briefly just to make good my submissions. 196 at 2.5 sets out the benefits provided by the GUA. And it says that the main benefit of the GUA for reinsurers and for the market as a whole is that it provides a clearer, codified agreement process with a unified approach to contract alterations. Now that's what we say it's being used for here. The key bit, we say, is part 4, page 198, which sets out what is evidence of agreement. And it provides here that the slip leader, and if you'll remember, that was identified to be partner re, shall, and we say that's important because it's mandatory, incorporate the GUA stamp in the endorsement, should it not be incorporated in or appear on the form of the endorsement. And then 4.2, the slip leader shall then initial in the appropriate box the level of authorization required. Now, that wasn't done here, and we say it's mandatory. Now, I accept, as my learned friend says, that the GUA is generally directed towards circumstances where there's more than one underwriter on a layer, and it's generally directed to what one underwriter can do to bind other underwriters, but it does have formalities, and those formalities were expressly chosen by these parties to govern what amounted to a contract change, and we say that they were not followed. Now, just to make that point good, it was followed, we say, in the prior year, and that is in the supplemental bundle, tab 2, and page 50. I'm sorry, tab 3, and page 50. And that is what a GUA endorsement looks like. It's headed contract endorsement. It says contract changes. It has the stamp that we just saw. The date is not in the box, but the date is on the right-hand side in the stamp. It does everything that that contract change provision requires it to do. Now, we say that by virtue of decision of MWB and Rock in the Supreme Court, it is the case that such clear clauses requiring parties to follow a particular route in order to change their contract are effective to bind the parties as to future changes. I think I will have to go to that authority very quickly because we say this is an area where the judge went wrong and it's relevant to rescission as well. It's in the authority bundle, volume 1, tab 9. There's a case to do with a license, and a counterclaim was made saying that an agreement had been entered into orally to vary payment under the license, and a no oral modifications clause was part of the license. Page 178 in the middle of the page is the clause which provides that all variations to this license must be agreed, set out in writing, and signed on behalf of both parties before they take effect. So there are two requirements there, one that it's in writing and two that they be signed. And we say that second requirement of a signature is a formality requirement, the same as the GUA requirements. At paragraph 7, Lord Sumption, giving the majority judgment, sets out in the middle of paragraph 7 the reasons which are almost invariably given for treating no oral modification clauses as ineffective. And one is the variation of an existing contract is itself said to be a contract. Now that's what the judge found here. that is what we say, in essence, would be an implied rescission finding. But as we can see from paragraph 10, that analysis was roundly rejected by the assumption. And he says, in my opinion, the law should and does give effect to a contractual provision requiring specified formalities to be observed for a variation. The starting point is that the effect of the rule applied by the Court of Appeal in the present case is to override the parties' intentions. They cannot validly bind themselves as to the manner in which future changes in their legal relations are to be achieved. However clearly they express their intention to do so, in the Court of Appeal, Lord Justice Kitchen observed that the most powerful consideration in favour of this view is party autonomy. I think that is a fallacy. But that fallacy is what the judge said here. So if you're with me, that the GUA is incorporated and that it was not followed, then we say as a matter of formality, the MRC was not varied by the facultative certificate.
And that would be so on your case, would it? Even if the parties had exchanged emails in which they said, we agree to get rid of the MRC and have the MURA instead.
Yes. And I think it's Lord Briggs.
And they could sign that in blood and it still wouldn't work.
No, it wouldn't.
Yeah.
And that is, I think, Lord Briggs's dissent. Lord Briggs would say that was sufficient. But he was in the minority, and we say that is not the law.
There still seems to be a situation, maybe it's just me, where the operative legal instrument is the license. Things contained within the license, be it the document or the legal instrument, are altered. But is it going so far as to say, if the parties say, we have no truck with this license anymore, we prefer a different license, governed by the laws of a different country that we like better? This applies to that situation, does it?
Well, I mean, and that is Lord Briggs's approach at paragraph 24, but he is, as we say, in the minority. He says, in this case, the alleged oral agreement to vary the licence said nothing whatsoever about the no oral modifications clause, and I would not treat it as having been done away with by necessary implication. But he does leave open the door that there can be necessary implication, and he recognises that in that sense he departs from the assumption. So that, we say, is to follow the minority, which is not good law.
There is a difference between variation and a new contract. And what I'm worried about is whether this is, and it becomes darker when it's new contract done by different laws, is Lord Sumption's decision really saying that the parties to a contract cannot bring the contract to an end by agreement?
Well, they
unless they follow the modification procedures if they were to change the contract.
Well, they can bring the contract to an end in terms with its cancellation provisions, in terms with its modification provisions. But they can't, we say, bring the contract to an end simply by impliedly entering into a new contract, because that's the very approach that is disapproved of here. It's not itself a separate contract, a new contract. There's no implied rescission. So we say, if you're with me, that there is a requirement to follow a particular provision in order to amend, then we say that is determinative of the matter. I do, however, put my case a second way, which is to say, if you're not with me that it's a strict formality, we say that this is again another factor that can be weighed in to the balance. On the basis, we say that if the parties agreed a modification provision and did not follow it, then that's something that can be taken into account in interpreting whether that document was intended to vary.
All of Lord Sumption's reasons in paragraph 12 for adopting the rule which he does are concerned with the problems of oral modifications,
Yes.
and the lack of certainty and so forth, but don't have the same force and perhaps don't apply at all where you have got a written agreement.
Well, my Lord, I suppose two things. One, this no oral modification clause was not just no oral modification, but also was signatures, and one can see from paragraph 17 he gives two reasons why it fails, namely for want of the writing and signatures prescribed by clause 7.6. So I suppose that's my first point, is that paragraph 17 makes clear that it's both written and the formality. My second point, my lord, is that there are different commercial justifications, but equally good justifications in this case. And that is that, for example, it makes clear to the parties which documents are intended to have contractual effect. So that's different for the justification for no rule modification clause, but there are commercial justifications for it here. They weren't addressed by Lord Sumption because he was looking at a different point, but I'm not sure that that changes the ratio and the applicability of that decision. I'm going to very quickly address the points that I think are taken against me by Partner Ree that I have not yet covered. The first is implied rescission. Implied rescission is said to be implied when a second agreement is so fundamentally inconsistent with the first contract that the only inference that can be drawn is that the parties no longer intended the earlier contract to be performed. Now, the first observation I make is my learned friend's primary case is that the contracts are being read together. So that rather undermines the implied rescission analysis. But my second point is to say, well, looking at all of the interpretation points that I've made whilst going through the documents, it isn't a case where it's so fundamentally inconsistent that the only inference that can be drawn is they intended to supersede. In fact, we say that the proper inference is that it was intended not to supersede. So we say that there's significant overlap. I've covered as well, I think, the facultative certificates being envisaged to come through at some stage. My point simply is envisaging they come through at some stage doesn't tell you what they are to do. It doesn't tell you whether they're intended to have contractual effect or vary. I accept that the facultative certificate is headed agreement and could on some views be viewed as a contractual document. But my point is that in comparative terms, it is not the contractual document. My learned friend has a point that there is a books and records clause in the facultative certificate which is not in the MRC. My response to that is simply to say, well, that doesn't tip the scales. When one looks at everything that is in the MRC and not in the facultative certificate, the books and records clause pales into insignificance. And that was the bespoke agreed communicable disease clause, the complete insuring clause, the limits provision, the requirement to maintain primary underlying insurance, the uncollectability of underlying insurance, claims control, several liability clause. We also say as well that the books and records clause is in itself of an administrative form, and so perhaps isn't something that one would be surprised to see in an administrative document. I've covered already the conclusion of the facultative certificate as a precondition to payment. We say that doesn't make it contractual. The entire agreement clause I will address in reply if I need, but we say simply it's circular. The entire agreement clause only applies if the facultative certificate applies. And then finally, on the two clauses being read together, the judge was not impressed with this argument, and I say rightly so. What my learned friend seeks to do is to read across two separate documents, an arbitration clause and a jurisdiction clause, where the jurisdiction provided for is different from the seat of the arbitration. And we say this would be the first time that that has ever been done. The cases that my learned friend relies on can we say all be distinguished on that ground. Ace Capital is an arbitration and a service of suit clause, both in the same document. Sul America is both clauses in the same document, one's Brazilian, one's London, but they are in the same document, not separate documents. And Surrey and Suez is two separate documents, but one agreeing the other one continues to exist, and in circumstances where it's London arbitration and English jurisdiction. So one can see why one might read those together, but not in this case. Now, I can see that I'm just coming on to ground two, and I am at the point in time where I said I would sit down. I will say it very quickly and reserve what I can for my reply. Our point is, and I'm doing this at a high level abstraction now, we say that the judge went wrong because the judge, although he said it was a contingent finding, he in essence failed to put delay in its proper context. The judge's reasoning was, we say, infected by the fact that he had found there was no exclusive jurisdiction clause. And that's why, when he discusses the points of delay, he doesn't mention the exclusive jurisdiction clause. And we say that that's important, both in the context of the fact that this is an arbitration and in the context of the fact as to how far this arbitration had got. In particular, though, we also say that he failed to weigh up the fact that if the arbitration continued, it would be a breach of the exclusive jurisdiction clause. And one needs strong reasons in order to show that that is a reason for not otherwise granting the injunction. Now, the judge instead looked at this as saying, well, are there solid grounds on the party seeking the injunction to excuse the delay? And we say that was about face, and that was because he had found that there was no exclusive jurisdiction clause. We say that that put the burden on us, but it put the burden on us in the wrong way. It's strong reasons against which are important. He also failed, we say, to properly take into account the fact that in this arbitration, there had in essence been nothing substantive that had occurred. We had gone to the tribunal. We had not asked them to determine jurisdiction, which is a point taken against us by my learned friend, but we had asked them to stay the arbitration pending the determination of the Section 9. That, we say, was a reasonable course to take. Rather than run off to the English court and seek a coercive remedy from the English court to injunct the tribunal, we asked the tribunal to stay pending determination. Now that then takes us up to September, and the application was issued about 6 weeks later in November. Now I accept that there might be some debate as to whether that point from September to November might be said to be delay that needs to be justified. We say that when one weighs that delay of some 6 weeks, it certainly doesn't outweigh the right for a party to litigate in the forum in which it has contractually agreed will it be the exclusive forum. It also doesn't take into account the fact that the arbitration agreement on that finding just simply doesn't exist. And it also doesn't take into account the fact that comity, which is a feature of delay, weighs differently in arbitration in circumstances where there's no offence caused to the foreign jurisdiction, the foreign court, there's no taking away of resources from the state of the foreign court, and there's no taking away of court time from other litigants. And so we say that had the judge stepped back, viewed it through the lens of there being an exclusive jurisdiction clause, an exclusive right to litigate in this country, he would have looked at that. He would have also assessed that the period up until the end of August when the tribunal was being constituted, the immediate request for a stay, and the period until mid-September when that was dealt with, were not delay, and the period from September to November of 6 weeks was certainly not a delay of an order that would otherwise justify failing to injunct a party when there is otherwise an exclusive jurisdiction clause.
Well, I don't know about comity. The American courts might well take a dim view of a foreign court injuncting an American arbitration. If a foreign court were to injunct an English arbitration, the English courts might not be very happy about it.
Well, I suppose I say this, which is that that doesn't weigh in the same way as if it were preventing court proceedings itself. The curial court role is rather more limited than the court's role when it is the substantive court of the dispute, and so we say that is a factor that is relevant.
It seems to me your real point is that even if there was delay, the judge never really stood back and considered the consequences of not granting an injunction, which is that both the English action and the arbitration would proceed, leading to either a race to judgment or procedural chaos.
Yes, my lord. And that certainly we say is the result of his error. And it's part of his error as well. And we say that's all driven by the fact that he had found against us on the first. Now, I suppose I'd better say something very briefly, because my learned friend says that this is all an exercise of discretion and you shouldn't interfere. We say, first, that where it's a contingent finding, and it's a contingent finding of the nature that it was, and where one can show that actually, because of the nature of the contingency, the judge went wrong, that is something that the Court of Appeal can exercise afresh. And second, we say that in any event, if I need to, then I say that the judge applied the wrong test, or left out factors that were relevant, or took into account factors that were irrelevant, which are also grounds on which this court can exercise it afresh. We say that this ground is largely driven by the conclusion on the first ground, and the judge, having found against us on the first ground, failed to properly I took that rather quicker than I'd hoped, without any reference to authority. I think I've reserved 10 minutes for reply, which I may need to. May I just check if there's anything screamingly urgent that I should say? My lady, my lords, I'll sit down.
Thank you, Mr. Killen. Mr. Broadback.
My lady, my lords, I will. I assume you want me to carry on until 1 o'clock, and then we'll take a break.
Yes, please.
Very good. Tickle's appeal on the first ground, attack on the judge's findings, suffers, in my submission, from a fundamental weakness. It fails to answer the critical question, indeed a question that your ladyship and your lordships have been posing in various ways this morning, which is this: why did the parties exchange and agree the terms of the Mura? And if you'll forgive me, I'm going to refer to it as Mura, but you understand what I'm referring to. So why did the parties proceed from the outset, as one sees from the email correspondence, on the basis that the Mura would be agreed? Why was it then sent to partnery by Tickle's broker with an express request to consider and to agree it? Why did Tickle and its broker make payment of the premium under the reinsurance dependent on partnery agreeing the Mura? And why did partnery review, stamp, sign and return it? Tickle's submissions provide no answer to these questions. And indeed, I should say, we'll look at the Mura in due course, but that question, all those questions arise with the same force, even if one is just looking at page 1 and part of page 2 of the Mura, as was from a certain point, suggestion was being made to you by Mr. Killen. The fundamental problem is that although Mr. Killen invites you to treat the Mura as insignificant, that's not what it says on its face, and it's not how the parties in fact treated it at the time. As to the second part of the case, which I suspect, like Mr. Killen, I'll have to take quickly, we say here one is unequivocally concerned with the exercise of a discretion. The question simply was, and this was the question the judge posed himself, assuming the jurisdiction clause to be applicable, should the court provide discretionary relief? We say the judge took a robust, common sense approach to that question, and that in doing so, he referred to the relevant principles and he applied them, including, for what it's worth, recognising that anti-arbitration injunctions may raise different considerations, at least considerations applied with different levels of force from an anti-suit injunction. So we say there was no error of law in that part of his decision, and that Tickle's attempts to construct one are unconvincing. So with that, I'm not going to take too much of the underlying material because I appreciate that you've been shown some of it and you've also read it for yourselves. But it is worth, I think, starting with the email at tab 10 of the supplemental file. Page 164, which you haven't been shown today, but I'm sure you've seen. This is from Lockton to my clients on the 7th of July. And it says, please find attached the fact set, that's the Mura, for agreement. If you can consider and agree as soon as possible, then the processing of front funds, etc. can begin. Now, that is an important email for several reasons. My clients are not simply being asked to note the Mura as an inconsequential administrative document, or just a confirmation. It is being provided for agreement. Partner is specifically asked to consider and agree. But on Tickle's case, on Malone and Friends' case, what is there to consider? It is essentially an irrelevance, a purely administrative document of no significance. And similarly, on Malone and Friends' case, why does partner need to agree? It has no effect.
Well, what he says is agree that the information is correct, broadly. They haven't got the wrong number on the policy. We've already seen the fours are switched around and things.
Yes.
That's what he says. Could give meaning to those words, without meaning agreement having contractual binding force.
I understand that, my lord. But in my submission, that is very much reading down the words of this email, and of course giving no weight to the fact that it's also said that premium will not be processed until it's agreed.
But it's due and payable upon to Mr. Gillen, that's just a mechanical thing. We won't let you have the money you're entitled to have until you confirm that the schedule is correct.
Yes, and Mr. Appellant has never explained why any confirmation of any sort is necessary. He said at length that the MRC tells you what the terms of the reinsurance are. The broker has that. The reinsured has that. We are not told in Mr. Gillen's version of events why any confirmation is necessary at all. Now,
Well, he says it's a summary of the cover.
yes, but that runs into the difficulty that, for reasons that he was submitting to you, it isn't, in the sense that it is on different terms. So that also is a difficulty for him. And it may be useful to pick up at this stage, I can do it just before we break, the point about a certificate. Because, of course, generally speaking, certainly in this jurisdiction, when one talks about a certificate, it is simply a confirmation to the insured, for example, or the reinsured. Here's the cover. And typically, such a certificate is issued by the broker, not by the insurer or the reinsurer. But the broker will say to his client, this is a summary of the cover that I have obtained. That is what a certificate generally is. And indeed, you were shown a reference in the MRC to the potential for certificates to be issued. And it said something about without reference back. I can't remember the exact language, I can show it to you if it matters. And my submission, that is envisaging the sort of certificate I've just described, i.e. something that would be issued by the broker without reference back to the reinsurers, simply to say, here in summary form are the terms that I have procured for you. We're not talking about anything of that nature in this case, and that's obviously going to be relevant also when I come on to the clause 33 point that my learned friend made towards the beginning of his submissions, where one of the submissions I'll be making is that this is not sort of certificate that clause is referring to at all. So even if it's incorporated, which I don't accept, it doesn't capture this particular type of document. Now, I think the next thing I was going to do was to go to the Mura itself, so it may be convenient.
And so that's better to do after the short adjournment. But I think we'll sit at 1:55. Thank you.